Thank you and good morning. Before I call the first case, I'd like to introduce the panel to you. To my right is Justice Vicki Henry, and to my left is Justice Marguerite Grant, and my name is Ariane Vuono. I want to remind everybody that you each have 15 minutes to present your argument, and that we've read your briefs, appendices, and everything that you've presented to us thus far, so we're very familiar with the record and your arguments. And you may want to get right to your points as soon as you can. I want to also remind you that there is no rebuttal in the appeals court. So the first case we have on the list today is 2022-0042, Commonwealth versus Darryle McClure. Good morning.
May it please the Court. Good morning, Your Honors. My name is Jennifer Peterson, and I'm here today on behalf of Mr. Darryle McClure. Your Honors, I believe this case raises the question of how attenuated can evidence be before it, while it can still be considered reliable for purposes of finding a violation of probation and impacting a defendant's liberty interests. Here, as I'm sure Your Honors know, there were 3 different probation violations raised, new charges, failure to complete an anger management class, and failure to report to probation. Only a single witness was called, despite some being summoned. Only a single witness testified, and that was Mr. McClure's probation officer. And this resulted in the fact that defense counsel couldn't meaningfully cross-examine her, given the different issues that were raised. With respect to the new charges, the probation officer had no personal knowledge of any of this. She brought in...
But that's not required, is it? That she would have personal knowledge in a case like this?
No, it's not required that she have personal knowledge. And even though hearsay is allowed, much of the hearsay that was admitted, especially with respect to the new charges, was totem pole hearsay. But even just as a preliminary matter, I think the fact that Mr. McClure was found not guilty on these charges in and of itself should have raised some kind of it calls for the judge, I would think, at a probation violation hearing to question the reliability of this kind of testimony, especially when it's coming in as hearsay testimony.
I think Justice...
The standards are different, though. He was found not guilty, but that's proof beyond a reasonable doubt. And isn't this a much lower burden of proof here?
Yes, it is, Your Honor. But what I'm saying is the fact of the not guilty should necessarily set up some alarms in the probation violation judges, even though the standard is lower at a probation violation hearing. The judge, being aware that there was a not guilty verdict, it should give the judge pause when considering how reliable is this evidence if this evidence ultimately resulted in a not guilty verdict down below.
What makes you say that you've just reiterated that this should give the judge pause, but what makes you think that the judge ignored that fact? The judge was made aware of the fact that there would have been a not guilty, correct?
Yes, Your Honor, he was aware, but I would suggest, because this was not only the different pieces of evidence, the 4 different main pieces of evidence, the police report, the GPS records, the video footage, and the hotel bill. Those were all not only hearsay, but they were totem pole hearsay.
Well, the video wasn't hearsay, and the bill, the receipt for the bill to the Fairfield Inn, I believe it was, right?
Well, I would say with respect to the video footage, defense counsel couldn't really meaningfully cross-examine as far as that. We don't know, how where the camera was, how, accurate the time stamping was. And even it conflicted. That what happened in the video seemed to conflict with the alleged victim's report and the police report, saying that,
Did your client seek to call the alleged victim at the probation hearing?
It was my understanding that she was summoned but did not appear. So.
And did your client object or ask for more time?
I believe my defense counsel objected to the fact that she could not cross-examine anybody with respect, aside from the probation officer, with respect to this video footage. So, So with respect to that, there was testimony there that the alleged victim said she was, to the police officer, that she was being strangled, and that it didn't stop until someone came up, when a hotel staff came up, but that is not what's indicated in the video. That's not what's shown in the video here.
Well, in the video, we can't see what's happening in the recessed doorway. I mean, he clearly lays hands on the person. What we see is her being thrown about the hallway, right?
Yeah, briefly, yes.
Well, repeatedly.
So, and it also, I would suggest, seems to show at the beginning the male touching the female, like, gently, and she's responding, and there didn't seem to be any kind of issue early in the video while she was sitting on the floor with her back to the camera. But you could see her arm kind of going up and touching him gently, so there didn't seem to be an issue at that part of the video. But it's hard to tell. There's no audio. There's no one there to ask. There's no staff members. With respect to the other two probation violations that were raised, the anger management class, I would suggest that the probation officer couldn't really be meaningfully cross-examined with respect to that either. Mr. MCCLURE did attend three of the 12 ordered anger management classes. The class was canceled because of the COVID emergency, and he had to work with someone remotely. He was arrested on these new charges I believe in May when they took place, and did not continue while he was incarcerated to go through the anger management classes. But I would suggest that you can't show a willful violation of someone who was attending classes and who did so until they were canceled, and then had no ability. A probationer needs to have the ability to adhere to the different conditions of probation. And while he was incarcerated, I don't believe he was offered any type of anger management classes during his term of incarceration. And then I believe he wasn't released based on the defendant's objection to probation retainer document that was filed with the court. It appears that he was released on September 9th of 20. And that goes to his whole failure to report. Conceivably, he reported, according to the probation officer's own testimony, conceivably he reported on 9/11. She said that she ordered him to report and that he didn't. But on page 21 of the transcript, she hedges and says even if he did come into court, he was supposed to have gotten a new GPS attached. And she said, well, he didn't do that. But that wasn't really in there. What she violated him for was the failure to report. But I would suggest that the testimony she gave was equivocal with respect to that. Excuse me. If the court doesn't have any further questions, I would respectfully request him to vacate the finding of violation of probation against Mr. MCCLURE.
I'll double check to see if we have any follow-up questions. I don't.
Thank you.
Thank
for
you, Your Honors.
argument.
Good morning, Your Honors.
Good morning.
May it please the Court, my name is Rob Kidd of the Bristol County DA's office. I'll just start with the evidence one piece at a time. As counsel pointed out, there are 4 pieces of evidence here. It's a police report, there's a GPS records, there's a hotel bill, and there's a video. So, starting with the police report, Your Honor, the police report contains significant first-hand observations. The police officer responds to the lobby of the police department. He's speaking to the victim. She's crying. She has visible injuries. That is consistent with her story to the police, which was that she was assaulted in this hallway by the defendant who tried to grab the keys from her. That video, that police report is corroborated by the video, which does depict an African-American male assaulting a female in the hallway. And as we know, the probation officer, in fact, did identify the defendant in that video, Your Honor. So that would be the police report. The police report is also corroborated by, there's a statement in there from one of the hotel employees that there was yelling and screaming heard in the hallway. That corroborates that there was some sort of domestic or some sort of argument in the hallway. With respect to the GPS coordinates, Your Honors, the probation officer herself testified that she put this GPS bracelet on the defendant. GPS technology, as one of the cases said, is now widely accepted and widely used. The probation officer mapped out the route of the defendant while he was on the bracelet to that hotel where the assault occurred. She marked it up with a highlighter. She testified that she went online and she looked up the longitudes and latitudes, and that's how she produced that map. The defendant cites a case, some cases. The Thistle case was one that recently came down. It was GPS in a probation violation hearing. But in Thistle, Thistle found that Thistle said that ideally these records should be certified by the probation officer in the future, or by the GPS company in the future, in order to avoid some of the questions. That didn't happen in this case. But nevertheless, Thistle found that the records were internally consistent, were detailed, and so forth. There were a printout of records. It was the same thing here. These were detailed records with the name of the defendant on them, date and time on them, and so forth. I suggest that the records do comply with the requirements of Thistle. We have the bill from the Fairfield Inn. I guess, again, I say that speaks for itself. It shows that someone in the defendant's name did check into a room in the same hotel where that video came from, where the assault occurred. Defense counsel could have made the argument at the hearing that, and probably did, I believe, that that's just a bill and it doesn't show much, et cetera, but that's the weight of the evidence, not its admissibility at the probation violation hearing. The video, again, it's a question of authentication. I think for purposes of the hearing, it wasn't hearsay, and it was properly authenticated. The probation officer who testified herself said she got it from the chief of police of the police department, and the chief got it directly from the hotel, from the Fairfield Inn. With respect to the failure to report and failure to attend anger management, we know that the defendant did go absent without leave as of September 11th. The probation officer speaks to him on the phone, tells him, after he's been mistakenly released from the House of Correction, tells him that he's got to report. He doesn't appear on the court docket until February 3rd, which is like 6 months later. What happened?
I was confused about that. So defense counsel seems to say maybe he wasn't released till September 9th, and so the difference between the 9th and the 11th is within the 48 hours. But you're still saying there was months of him being absent?
Yes. Okay. And I think the record indicates that an attorney from Rhode Island made an appearance, and like 7 or 8 days after the defendant didn't show up, after the warrant was issued, after that September 9th or 11th date or whatever it was, he filed a motion, not necessarily appeared in court, and the motion was to remove the warrant. So it appeared that the client had hired this attorney to go in and try to get the warrant lifted so he wouldn't be held. And the defense attorney, in her closing argument to the court, said, even sort of, as I said, kind of stipulated to this or conceded the point that her client should have reported, should have done the anger management, but she said on his behalf, he wasn't, quote, hanging in the wind. He did get an attorney. The attorney did try to lift the warrant, so on mitigation. So, yes. So that would be my argument with respect to the failure to report. And I don't know that there's anything else that I need to cover on this. If the court has any further questions, if they don't, I'll rest on my brief, and I will ask that the finding of violation be upheld.
So the panel has no further questions. Thank you very much for your argument. Thank you both.
Thank you, Your Honors.
I'll call the next case, which is